Mr. Summers, I'd like to start with you. Last month, I introduced a bill called the Critical Mineral Consistency Act. And I did this in order to try to align the Department of the Interior's critical mineral list with the Department of Energy's critical materials list. Can you explain for us, Mr. Summers, why both critical minerals and critical materials are essential to the United States, particularly with regard to our economic, energy, and national security?
Yeah, absolutely. Thank you, Mr. Chair. I applaud you for introducing this particular piece of legislation, because the disparities between the lists that the federal government has maintained, especially between the DOI list and the DOE list, has been perplexing to the mining industry for a number of years now. And in many cases, again, when you're talking about critical minerals specifically, a lot of these critical minerals, as I mentioned in my testimony, are co-located with base metals and precious metals and other things that may not appear on either of these lists. But in particular, in the case of Utah, again, our most productive copper mine is also our most productive critical mineral mine. And so making sure that you have equal consideration from the federal government for both the critical minerals and minerals like copper is really essential. The other issue that comes to the fore here is that, regardless of what national defense technology or energy transmission technology you're talking about, I mean, they're going to rely both on things like copper and on some of the more boutique minerals, that are on the critical minerals list. And so, while you have a large number of rare earths, for example, that will go into an F-35, which we have a lot of in Utah, you also need a lot of copper to make an F-35. You also need, vanadium for the alloys that go into those airframes. And so, again, having some consistency from the federal perspective when it comes to any potential fast-track permitting or grants and research and other things is essential in order for us.
Why does it matter for us to try to produce those in the United States rather than importing them?
Right, absolutely. I mean, again, as you've seen from the recent actions of China, I mean, if you have something like antimony, for example, that's banned, that prevents us from manufacturing munitions in the United States, because those are critical to go into, again, munitions and national defense systems and other things. And so it does become a national security risk if we're reliant on foreign producers, and especially adversarial foreign producers for those minerals.
Makes sense. Mr. Haddock, in your testimony, you noted that Nevada, where Barrick operates, is a state with a lot of federal land. And Utah faces, of course, a similar challenge, with 67% of our land being owned by the federal government. When it comes to mineral development, what additional hurdles do companies face when trying to develop these things, when they're operating on federal land as compared to either state land or private land?
The additional hurdle is permitting. It's the timeline for permitting. The permitting timelines on state or federal land would be much quicker, and then, of course, the litigation risk on the tail end, where almost every project is litigated. It makes it very difficult to spend a lot of money. Like some projects, you would spend $500 million before you get to the point of permitting it. That's a lot of money to sit there for a long time.
But when you're going in to operate on either state land or private land, there's still permitting required. There's still a potential litigation risk. Tell me how that risk and the corresponding delays compare between the two.
There is kind of a broader range of litigation risk because of, number one, NEPA. The agencies, the federal agencies that administer the public lands do an absolutely great job of bringing together mountains of data, analyzing all the range of issues that they have to that they have to consider under the various laws. But what tends to happen in those cases is that the courts tend to fly-spec the EISs and nitpick until they find one issue that they don't think has been adequately addressed, and then you're back to supplemental EIS.
Okay, so does that suggest that the additional time consumed in the federal process doesn't necessarily produce a cleaner, safer outcome? It's more fly-specking and time-consuming, but not necessarily with a corresponding benefit to environmental quality. And if this is the case, how does this impact, how does that situation compounded by recent court decisions. How does that impact investment and project development?
Well, it makes it harder to invest, but you're absolutely right. NEPA was enacted before many of the detailed federal environmental laws that have performance standards. And what commonly happens is, whether you're working on state land or federal or private land or federal land, you have to comply with all those laws. What typically happens through an EIS process is additional mitigation measures are imposed, additional performance standards are imposed, and then they're litigated over. So that's kind of the additional burden from that.
Thank you. My time's expired.